Lords, if I could mention a pending matter, there are three connected writ petitions, my lord. In the month of February, they were referred for special mediation drive, and the 60-month period under that is completed. Thereafter, another 30 days, but the matter still being, the parties are still discussing.
We'll see after vacation.
We were asked to mention, failing which they said that the file would be sent back, but in May also the parties are willing. So I'm just requesting that the matter may be listed so we can get an extension of 30 days from this honorable court. The parties are willing to settle this matter, but there are many parties involved. There's a bank, there are two builders, and there are plot owners. So I may pray that it may be had tomorrow, my lords, just for the extension.
Yes.
My lords, kindly, one matter, in fact, your lordships have disposed of, granting me 6 months' time for 6 installment. I have deposited that amount also. The only thing is, my lord, one loan is completely closed, and the property which is given as collateral in respect of one loan, my lord, I have requested for discharge of that property. But they say, my lord, in view of the order passed by this honorable court, that there should be a specific order from this honorable court. For that reason, my tomorrow.
My lord, challenging sale notice, my lord. The earlier sale notice was challenging DRT, stay was granted. After that, in spite of that order also, they have,
Which year is the writ petition?
my lord,
Which year is the writ petition?
new matter, my lord, fresh matters.
If it is without.
My lord, it
office
was
objections
supposed
are
to
complied,
listed
it will
today, my lord, it is not listed.
Look at it. If office objections are complied,
Yes,
let it come
complied, my lord.
tomorrow.
It is urgent matter.
Huh?
Illegal demolition the house. It is urgent matter.
Which year is the writ petition?
Cooperative Society, Malaysia.
Which year is that?
A fresh matter, man.
Fresh matter, this court has no roster.
Please kindly status quo, man.
Huh?
Illegal demolition, man.
Cooperative,
Fresh matter go to
Yes.
fresh matter.
2024.
Milords, it is 24, milords. 24.
24 matter, what is urgency now?
It's a illegal demolition, my lord.
We'll see after vacation, not now. Yes.
Milords.
And the borrower already DIT possibly restored the position by the banker.
Fresh matter pending.
It is earlier net, 2024 net.
24 matter will be taken up when it comes.
Milords,
Yes.
serial number 23, milords. Milords, counsel for the petition is unwell today.
Call, she'll call the,
Page number 2, serial number 3 to 6, number 3, 7 to 13.
Serial number 12, my lord.
Hmm.
I served the copy of appeal and judgment to the advocate, my lord. Advocate P. Pradeep. And, advocate on record, my lord.
13, 1-3.
12. 12. my lord.
This is matter after vacation. Admit, post for final hearing. Yes.
Page number 4, serial number 14 to 19. All other dismissals. Page number 7.
Started matter you are mentioning.
Serial number 23, milords. Counsel for the petition is unwell today, milords.
It is submitted that the counsel for the petition is unwell. This is matter after vacation.
Objections are ready in this matter, my lord. Objections are ready in this matter, my lord. 23.
I will take the objection, milords.
Give, sir, him.
Please, my lord.
Then counsel for the respondent. Learned HCGP.
take note.
Has served the objections, has filed the objections and also served a copy of it on the counsel representing the petitioner.
To consider the representation, my lord, which was given to the President of India, Home Minister of India, that my lord.
That's on facts. I'm
Is
not-
the
I'm not
accused in
aware.
four-
On facts.
Yes. So those many are the representations. Yes. Huh? And delete from the caption.
Page, that's number.
Yes.
The page number 7, serial number 27. Page number 8, 28, 29. Page number 9, 30 to 32. Page number 10, serial number 33, 34.
Yes.
Page 1 for orders matter. Serial number 1, Monica Patil for petitioner.
Matter arises under the KPID Act. What was being contended by virtue of filing IA number 1 and 2 is that 3 notifications are involved. The notification under which the act provision under which this notification came to be.
Please come to the prayer. Let me first understand what it is.
The issue involved here is
Come to the prayer. Let's see the prayer.
prayer in the petition is for what?
Ladies number.
I have to be clear,
How you are questioning it before this court?
Your Lordship, that prayer A does not survive here, because they have since withdrawn the petition itself against us.
Then,
But only the second one, certiorari to quash the notification, that alone would remain. I have to be fair to this court.
what is the notification issued under 3.2?
3-2.
Why should it be questioned?
My contention is that the section has since undergone change, and in the light of para 37 of the Kolhapur cane, having been amended without a savings clause,
Here's for the, who is he? Where is he?
He's on his legs, my lords. He's assisting in court order 23.
Let him come,
Please.
short passer.
Please. Great.
Cell number 2.
it requires, in my humble submission, requires your Lordship's consideration.
We'll decide it now itself. Once he comes, call this matter.
Please.
Cell number 2. One of the case.
It will be taken up at 2:30 minutes. Just request for a passer.
2:30, it's doubtful today. Tomorrow?
Tomorrow minutes.
Tomorrow. What is that expression, Mr.
No,
Ramesh?
tomorrow one minute part heard matter before quotal number 21. Yesterday's matter.
Partner will be taken up afternoon, isn't it? In the morning itself they'll take.
Today took minute in the morning, seal number 1. I don't know. At any minute, I'll assist this court tomorrow. No difficulty. Senior have some problem.
No, or else we'll do, we tentatively pass over. If
Please,
not
my lords.
possible, take it up tomorrow.
Very well, minutes.
Cell number 3.
Let's,
Interlocutor applications. P. Rajshekar.
First respondent in this case.
The second respondent.
Yes, L&T Housing Finance Limited.
let's, can I just persuade you, Lords, may kindly have a look at para 68 and para 69 of Madia Chemicals case, because this issue was what fell for consideration. Lords, even the recent judgment of the Supreme Court said that where it can be interfered, where it should not be interfered under 226, the dichotomy is drawn. Wherever the writs are based purely on the basis of the directives of the RBI, though having the force of law, and the bank is discharging public functions, if it is not otherwise a public functionary, then it cannot be maintained. But the exception is where such bank exercises powers under a statute.
So we'll see this judgment, this court officer,
Muthoot case, Milords, is it?
the other one.
That's 2026, the recent judgment, Milords.
Vishwabharati's judgment.
I just have a look at that judgment.
That is, it has categorically, like, it has discussed about everything. What all you are submitting, all have been dealt
Can
with.
I just, because Madia Chemicals, I'm not sure whether it was dealt with, because there are two principles, if your lordships may recollect, Milords, that in, if I remember, it's in Rashmi Trading's case, Justice Vikramjit Sen, as he then was said, that if there are two judgments of concurrent benches, then the earlier judgment has to prevail, and it's not the latter decision, because if the earlier decision is not taken into consideration with the later one, earlier will continue to hold the field. That's essential
Considered,
by a coordinate bench.
considered by a later bench.
Milords, if it is
Then the-
considered by the latter bench, Milords, then of course the Supreme Court, whether it is said rightly or wrongly, Milords, I will not be in a position to say it before. Can I just see, Milords, because I don't know which is the judgment they are
Copy is
referring to.
not there. Copy, Vishwabharati. Give it to him. Look at it, I'll just pass over.
Very well,
Call-
my lords.
Yes, call the next matter, give that judgment to the. Hmm?
Cell number 1. Pass over the matter.
Yes, come, and then give the judgment to him first. Yes, one, what do you say?
Or if this could be taken up tomorrow, Milords, I'll just see the
Please
judgment.
look at it, both the Shobha, that Muthoot Finance one, and
But
also.
Shobha and Muthoot, Milords, is not on SARFAESI Act. And Muthoot specifically says, I read that Muthoot because I had to rely upon this judgment. Muthoot very specifically says, I think the last clause says, wherever any person has exercised powers under a statute and there is a statutory aberration, writ should be exercised.
But unfortunately, the.
Where the SARFAESI,
No,
Milords?
no, the High Court has taken a different view, having so expressed like 2-3 observation, but ultimately the view taken by the High Court is affirmed in Muthoot. But whereas in this Vishwabharati, they have dealt with all.
Milords,
asset
Milords,
reconstruction.
so far as Phoenix Arc is concerned, Milords, I have no difficulty to write away this. Phoenix Arc did not consider Madia Chemicals. As a matter of fact, I will place it before the court, Milords. Phoenix Arc was cited before the Supreme Court saying it should not be entertained. Supreme Court did not consider this. I can place the judgment. Should not be a difficulty, Milords. Phoenix Act, Milords, of course, it's a very old judgment. Justice Amarsh and Justice Nagaratna delivered this judgment. It was cited in the subsequent judgment. Supreme Court did not consider this, and an order passed by the High Court is upheld. Here is a case, my lords, where site is mortgaged for putting up construction. Then construction is put up. After the construction is put up, the sale is made as though it is a vacant site. The schedule is a vacant site.
We'll have this, the process.
Position of law.
Threshold thing, then we will go into that.
But see,
Yes.
because the question which came up for consideration specifically in Madia Chemicals case is not with reference to who is exercising the power. The question was when power is exercised under the statute, because what all categories of secured creditors is a separate genre altogether and for the purpose of SARFAESI Act. Once this secured creditors exercise the powers under the scheme of the SARFAESI Act, what should happen was the specific question which was answered in Madia Chemicals case. This again, my lords, the same thing. I am not sure whether Madia Chemicals was read to your lords. Anyway, my lords, Phoenix Arc and Madia Chemicals, tomorrow I'll address it.
And even the judgment where they said that the Phoenix judgment cannot be.
My lords, that judgment was cited. I have that. It's a very short judgment, my lords. I'll get that judgment.
But unfortunately, how do we look at it? When a two-judge bench judgment is.
That's the reason why I said, my lords, Rashmi Traders case dealt with this. It was faced with this situation. Then they said, if an earlier binding judgment, because Madia Chemicals is more like a grand norm insofar as SARFAESI matters is concerned to the extent it has been confirmed in the subsequent judgments. A specific question was posed in Madia Chemicals.
Judgment.
Please, my lords.
It is also a two-judge bench.
Lords, that's the reason why I said, if there are two judges bench judgments, one earlier in point of time which answers this very specific issue with reference to Article 226 and the provisions of the SARFAESI Act, which is not taken into consideration by the latter bench, then the Supreme Court said, of course, there are curtain of judgments. What I can immediately recollect from my memory is that Rashmi Advertising or Rashmi Traders case, which said, authored by Justice Vikramjit Sen, said that the earlier judgment has to be followed.
And other line of judgments are the earlier judgment which is considered by a.
Lords, if it is considered, my lords,
Then the later judge.
So certainly, my lords, the moment there is a consideration, then I will not be before your lordships to say that the Supreme Court should. I will never say that.
Phoenix judgment, Madia Chemicals was.
Lords, this paragraph, my lords, para 68 and 67 and 68, it's not there. That's the reason, my lords. What was specifically addressed in para 68? I shall go through it tomorrow, my lords.
Tomorrow.
Please.
Yes. Yes, first, madam.
Sorry, my lords, engaged in other court.
Yes, yes.
Apologize. But in fact, Lord, 3 matters were before this honorable court challenging the very same order. My lord has dismissed the companion petition. My lord, can you permit me to produce?
Take that.
So what is in challenge before your lordship, my lord, is the order passed to the honorable special court under section 5 clause 2 of the act, my lord, for which, my lord, there is a statutory remedy under section 16.
That has been withdrawn.
Plus, if prayer A is not to be considered, my lords, prayer B would not stand for consideration for this reason. Prayer B, that is, my lords, the notification has merged with section 5 clause 2 order. So if, my lords, 5 clause 2 order is, my lords, upheld, or it depends upon the, it does not, prayer B does not have an independent existence of its own. It does not have legs on its own to stand. So ultimately, my lord, since it has already merged.
Consequences of the notification is the order under 5.2.
Please, Lord. But section 3.2, my lords, is only an ad interim attachment. And this will be in force only till, my lords, the Honorable Special Court passes the order. Now that the Honorable Special Court has already passed the order, in a way, my lord, prayer B becomes fact accompli unless the final order is, my lords, dislodged. So under these circumstances, my lord, section 16 is the remedy. And on this, my lord, the companion appeal, companion petition, my lord, has been dismissed, my lord.
In my case, on the very line as being submitted, they withdrew the proceedings in the miscellaneous. If that has been withdrawn, then what happens to the notification? It doesn't stand by itself.
What will happen to that?
My lords.
He says that these proceedings are withdrawn.
No, please,
themselves have withdrawn it against us by filing a memo saying proceedings that I have produced at.
Then that also has to go.
Then notification has to
It
go.
also has to go. Look at it. Where is it?
No, that is rejected. Well, kindly see the order, please, my lord.
That's what. Let's see that. Where is it?
No, statement of objections, my lord, may kindly take.
No. He says he filed it by way of a memo. You filed or they filed?
They filed a memo.
Where is that?
They have not. I'm instructed that it's not produced. Your Lordship. But
My lords, I have produced a statement of objections. My lords, can you take page number 23?
So when is the
section R2?
memo dated? You must be having a copy of it.
The definitely the same order I have produced it, my lords, in terms of annexure R2.
Dated?
My lords, I have filed my statement of objections, my lord, on 17/3/2026, my lord.
17?
17/3/2026, my lords. If my lords permit me to hand over a copy, my
I
lord.
have it, 17.
Please, my lord. Annexure R2, my lords. Page number 23. My lords, it's like this, my lord.
It's an order
Please, my
at
lord.
page 31.
Please, my lord. Operative positions on 31. But it's like Ashwattama Hataha Narova Kunjarova is the argument. Kindly see, my lord. Yes, it has been withdrawn. At page number 31, I number so and so filed with the petitioner of the KPID is allowed. Consequently, the petitioner is permitted to delete the respondent number 8 to 26 on the respective properties on the petition. Next line, my lords, to kindly appreciate. So with liberty to file a fresh petition against them after the disposal of the respective writ petitions filed by them.
Like in the other case.
Exactly, same order, my lords. It's a companion petition. Because they sought time, my lords, your lords are kindly pleased to adjourn the matter.
my lord, my submission is otherwise, ma'am.
Yes.
Notification is issued under 3 to initiate action purportedly against an organization or an institution known as Vikram Institution. Whether it is a financial establishment, whether it comes within the definition of deposit,
That can be decided by the special court. Why
the
should-
special court case has been withdrawn. I stand nowhere now.
No, now they will do it. That's what I said so in the other matter. Have you given him a copy of it?
Yes, I saw that, ma'am. Lordship, the question is then where do I go? In the light of Menaka Gandhi's judgment,
After now, as of now, there is nothing against you. As of now, once they go before once this writ petition is disposed of, they will again move the special court. That is what was done in the other case. That's what I've directed them to do so.
Please, my lord.
Have you seen this order?
yes, I have seen it.
In the
Para
considered-
para
in the
five in fact.
considered opinion of this court in the matters of this nature, remedy lies before the special court, but not before this court. And if any order is passed by the special court, that can be questioned by filing an appeal, and they cannot come before this court by filing a writ petition. As well, these disputed questions.
Then my lords may keep all my issues open to be urged there before.
That is always there.
This therefore.
Please come.
When section 14 benefit may be given, my lords. When section 14 benefit may be given,
Yes.
I will not stand in the way, my lords. I will not gain on.
All
any
my
points.
contentions on both law
Anyway,
and.
section 14 will not arise now, for the reason nothing is pending
Please,
now.
please,
Unless and until you again initiate under
Please.
5.2,
please, my lord.
the present writ petition is filed. Seeking the following prayer. When counsel for the petitioner submits that the respondents have filed a memo stating that that an order is passed by the special court in miscellaneous number 250 of 2022, permitting the respondents to delete the respondent number 8 to 26 and their respective properties from the petition with liberty to file a fresh petition against them after disposal of the respective writ petitions filed by them. It is submitted that as such, prayer 1, page number?
Page 26.
Prayer A does not, no, there, as such, it doesn't, there is nothing to consider as far as prayer number A is concerned. Then with respect to the prayer number B and C, it is submitted that the issuance of a notification under section 3(2) of the act is bad. And before issuing the said notification, they have failed to even issue any notice to the petitioner, and the petitioner is not a deposit,
Does not come within the definition of financial establishment or a deposit.
institution, is not a financial institution, borrower, without even looking into this aspect. Issuance of a notification under section 3(2) of the act is bad. Land counsel appearing for the respondent, which respondent you are?
3, please, my lord. 2, sorry, 2, please, my lord. 2, please, my lord.
It
Point
is
number 2,
submitted that in view of the pending writ petitions before this court, basing on the memo filed by them, the special court has passed the order whereby the properties, whereby the
It was 31, my lords.
whereby the respondents are permitted to delete the respondents number 8 to 26 therein and their properties, and the liberty is given. It is submitted that once this writ petition is disposed of, they'll be again initiating the proceedings under 5.2.
Please.
Under 5.2, it is submitted that the petitioner has a remedy before the special court to question the notification that is issued under section 3.2 of the act. It is also submitted that in respect of similar matters, this court in WP number 5314 of 2023, dated 16th April 2026, has passed an order permitting giving liberty to the respondents to proceed in accordance with law, and petitioners are at liberty to avail the remedy available under the act, keeping all contentions open. It is submitted that even in this case also, a similar order can be passed.
Both on law and fact.
Same order can be passed. Next part, having other counsels on either side, peruse the material on record. In similar circumstances, this court has disposed of the writ petition. Para 6 of the order and the operative portion, both extract, reads thus: in that view of the matter, the writ petition is disposed of with the same orders, operative portion same, but both on legal and facts, that all contentions are left open. It's the only difference from one.
Lost permission, my lord. The other matter of the same batch, my lord, WP 418, has been reserved for orders, my lord.
Yes.
Please, my lord.
That is on a different issue.
Yes,
You were
yes.
arguing something else.
No, same, please, my lord. Same. It's
No,
my
that
lord.
is true, but he has raised all contentions, he has raised several judgments and all. All we will consider and
Please.
pass order. That's
Please.
why that's read.
Please.
That matter is reserved.
With
Yes.
your pleasure.
Yes.
Serial number 4. Serial number 4.
Section 14 order they have challenged.
Filing memo, my lord, that we have made payments of 4 lakhs, 8 lakhs, plus 7,48,000. They've also made violation of this honorable court. And there is stay, they issued sale notice, my lord. If I given copy of. By forcibly they've taken 7
What is
lakh.
the interim order? Then counsel, the petition submitted subsequent to the impugn notice dated. Out of total outstanding of 8 lakhs, the petitioner has paid rupees 2 lakhs to the respondent bank. The said submission is placed on record. Where is the interim order?
Interim order is there, my lord. I don't know.
What is the date of interim order? There is no interim order. What it says on 31/8/2024, interim order granted earlier, if any, is extended till the next date of hearing. There is no interim order.
My lord, when there was interim order, they that
No,
time
no,
only
please
they
tell
made.
me the date of interim order. Petition has paid to the respondent. Concept to accept notice. Deposit sum of rupees 4 lakhs on or before the next date of hearing. The respondent Bank of Baroda shall not take any precipitative action till next date of hearing. When did you deposit 4 lakhs?
My lord, that interim order they complied, my lord. Again, that interim order they complied, my lord. Again, on 31/8/2024.
31?
Court order 31/8/2024. Court ordered to deposit 2.5 lakhs that have not, that they are not complied.
4 lakhs we deposited, my lord.
4 lakhs complied, my lord. Again, 2.5
Then
lakhs they have not.
on 10/11.
31/8/2024, there is no order.
My lord, in web certification.
There is no order on 31/8/2024.
Possibly they've come to the
In
petitioner's
website it
house
is.
and.
In website it is there.
No, the learned counsel of the petitioner submits that the petitioner has deposited a sum of rupees 2 lakhs on 28/2024,
Yes,
rupees
ma'am.
50,000 on 38/2024, and rupees 1 lakh on 31/8/2024. Released on 5/9/2024. Interim order granted earlier, if any, is
My
extended in
lord,
the next
in
date.
4 lakhs, they have only paid 2.5 lakhs.
4
lakhs they have not.
2.5, 3.
Totally 8 lakhs we have paid, my lord.
Show the statement. When did you
I
pay?
produced in memo, my lord. Memo is there.
No.
Again, we have paid 7 lakhs 48,000, my lord. That is also.
2 lakhs, 6 lakhs. She has placed something like 8 lakhs they have paid.
Yes, my
Presently,
lord.
13
Again,
lakhs outstanding were there, madam. Still 13 lakhs were there, madam.
only loan was taken
Approximately
only.
13
First
lakhs.
of all, when there is an interim order, why did you issue an auction notice?
Yes,
That
my
is the
lord.
question.
They violated the rules, my lord. 10/11.
My lord, I will check in instructions, my lord.
The land counsel of the petition submits that in spite of an order passed by this court, the respondents have issued the auction
Attempted
notification. The respondent shall file an affidavit before this court why the auction notification is issued when there is an order passed by this court and the interim order is subsisting as on today. The respondents are directed not to take any, no, not to go ahead with the auction process. This is matter immediately after vacation. List on 10th of June.
So number 5. Latif B.
But the recalling application, my name was not indicated earlier twice, Lord. I have filed NOC Wakalat on 22/2/2026. But subsequently listed twice, Lord.
Where
And
is the cause list of that day?
that is 17/3/26.
Have you filed it along with your IA to show that your name is not reflected?
No, cause list was not filed.
How
Date
will
was
we
mentioned in
know?
the affidavit.
The writ petition was filed in the year 2025, came up before the court on 29/1, 17/3. On 17/3, there is no representation. Hence, the matter was directed to be listed today and the caption for dismissal. Today also, there is no representation on behalf of the petitioner.
Both dates, my name was not indicated.
Whose name is printed?
B. Latif, Lord.
Latif B, advocate for petitioner. That is there in the order also.
On 17 and 18, it was not indicated.
Then when is it indicated?
Now today it has indicated.
Whose name was reflecting?
Earlier council name was
When did you file your wakalat?
in the month of February, my Lord. 22nd February 2026.
20?
2nd February 2026, I have filed wakalat along with IAM, Lord.
Then you argue the matter, then we will hear the matter and see whether it's a matter to be, whether the order should be recalled or not.
Please.
Yes.
Same, Lord, this is a commercial complex and the petitioner has
What is
obtained.
the prayer you're seeking? Issue a writ of certiorari setting aside the order dated. Ask for respondent number 1. Who is respondent number 1?
Yes, this is sections 14 order, Lord, wherein, Lord, the 20 lakhs is the loan as obtained for the commercial complex. He ready to even deposit and he sought given a representation to.
Should have filed an affidavit by this time.
And he filed an application.
I will file an affidavit. I'll pass orders on that and then only I'll recall this.
Lord, kindly say annexure B also have given a representation. That was also not considered.
With an undertaking affidavit. That you are ready to pay. Within
Please.
what time? Then we'll consider. When?
Tomorrow.
Yes, tomorrow.
Then number 6. Yes, Rajesh Shekhar.
At the request, list this matter tomorrow. Then council submits that he'll come up with an undertaking affidavit that he's ready to pay the entire amount.
Not 50%.
No 50%. In this, before this court, no 50%. Either Either full payment or go to the tribunal. Only two things. That you please find out from your client. Yes.
Cell number 6, Ms. Rajshekar.
I pay for petitioner, my lords. This, my lords, may kindly recollect, my lords, we are neither the borrowers nor the, my lords, guarantors. Or they contend, my lords, we are illegal occupants of the apartment. My lords, on the last date of hearing, my lords.
Whether for the illegal occupants or they have issued the law, given the loan or not.
Yes, they have filed affidavit, my lords.
Filed affidavit.
Affidavit, kindly see, my lords.
Last hearing, my lordship has directed file affidavit.
File affidavit. Kindly see, my lords.
From that affidavit, my lord.
Para 2 may kindly seen, my lords.
Dated 2/4/2026.
My lords,
When is that? When is the affidavit?
It's
Affidavit was filed on
Look at it.
18th April.
18th April.
For these people to tie the papers also, there is no rule. Which paper to be first, which to be next. The respondent. You have a copy?
Yes, my lord.
Please pass on. Take that. It's there.
Documents are given.
Yes, let's see. What did they say?
Lords, para 2 in page 3 may kindly be seen, my lords. A.
Para 2 in?
Para 2, continuation at page 3.
No. Para 2 is at page number 1. I
Para-
state that the word petition.
Para 2, 3, then
Continues-
again 1, then again 2. Kindly go to page 2, my lords, of the affidavit.
Page 2, it has
Yes.
3, 4, 5 paragraphs.
I'm sorry, the copy what they have served to me.
How it starts?
Now, this starts with, I state that against the issuance of said e-auction notice. Para 2, my lord, page 2, my lords, last paragraph. In page 2, last para.
Against issuance of.
I state against issuance of. Kindly go to next page, my lords. There they have given.
This is paragraph number 5.
This is para 5, my lords. A, my lords, 5A.
Yes, that is 6A.
6A, my lords. 6A, out of 36 residential flats, my lords, you can see. Out of 36 residential flats, in respect of 9 flats, is flat number so and so, bank has granted loan to the borrowers to purchase the said flats. Lords, so conveniently, kindly see, take my memo, my lords. They have not included my flat bearing 201.
You have also taken loan.
Yes, I have produced the document. This is what my lords wanted to know on the other day. I have produced the document, loan sanction letter. They have conveniently, they have not mentioned this.
This para just I'll read, my lord, then I'll explain, my lord. The respondent number 2, proprietor of C.
No, before we read the entire paragraph.
Total 36 flats.
You have specifically mentioned, have you said so that in respect of some flats you have granted? It's a different aspect. When you specifically said out of 36 flats, we have given loan for so and so flat. Why the flat for which you have already given loan to the petitioner is not mentioned in this when you're filing an affidavit before the court?
One Vasudeva Bhatt, he has taken 2 flats. Vasudeva Bhatt is there. In his name, there are 2 flats. One flat come under this. Another flat he has purchased. Something like that. That is the matter pending before the court. Now this 36 flats, my lord, we are talking about 36 flats and this 19 flats. 36 flats I have given the details. Out of 36 flats, my 9 flats, bank has given the loan and there is a tripartite agreement. And I have produced the loan account stating that till today they are paying installments. That is usual procedure. Then another 8 flats, State Bank of India take as requested for no objection. 6 flats given no objection. Another 3 flats given no objection. And those people, the DMI is credited to the borrower's account. Respondent number 2. This is as per the procedure of the bank. So now out of that, then only 19 flats are there. 19 flats, we do not know because without the consent of the bank, that flats now they are occupying. And borrower, it seems they are entered into the agreement. These 19 flats only, bank has issued a notice under a sale notice. Now all other things it is very regular and as per procedure only. Whatever the loan sanction, there is a tripartite agreement and that amount we are getting and the statement of account is also produced. And State Bank of India, there is no issue, they have given the letter. Now, these 19 flats where the bank has issued notice, these flats, these are owned by borrower, respondent number 2. And they are not the owners per fact. And that under what circumstances they are an aggrieved party, it is very difficult to say. I have produced on Supreme Court judgment. They are not, they cannot be the aggrieved party. Aggrieved party means actually he should be the proprietary concern. He should be a proprietor. Here, except the sale agreement, there is nothing is available. This judgment of the Honorable Supreme Court.
You don't have sale lease here.
No sale lease is not there. Sale agreement only.
Lords, admittedly, my lords, we are all agreement holders. Now, my lords, since he did not come forward, lords, we have approached various courts. On the last date of hearing, I made the submission. We have approached rare authority. We have approached consumer court. We have approached the commercial court. We have approached, my lords, the civil court as well. And some proceedings are pending and some, my lords, ended in compromise also. In spite of that, my lords, initially when the bank brought the property for auction, then, my lords, we have paid the amount, whatever partial sale consideration to the bank. And, my lords, we got, my lords, the auction postponed with an understanding that, my lords, he will
Without
Oh my Lord.
without any document of title, why are you coming before the courts? and
Now,
fighting
the practical difficulty what we are facing, my lords, they say it is a project loan, what they have sanctioned to respondent number 2. On the one hand, my lords,
You have to settle this course with your builder.
that is what we have been selling, we have been, my lords, persuading with the
What they
bank.
will do, what the bank will do.
My lords, we said, my lords, there is commercial space. There are, my lords, about,
No, you have to settle your disputes with your owner.
he is not coming forward. My lords, though warrants are executed, though, my lords, the warrant,
But what you can't do with your owner, how do you expect the bank to do something?
my lords, we are requesting the bank, my lords, we are all bona fide purchasers. You are ultimately, you are worried about your money. We are saying, my lords, we are ready to give you your money.
Ultimately, he has mortgaged the property.
Please. Now, if the bank auctions the property, my lords.
No, he has mortgaged the property.
Yes, my lords.
Without the consent of the owner of the mortgager, how will they give
Now,
possession?
my instructions are, my lords, he has also agreed, on principles to, my lords, settle.
That is not the realm in which High Court can go into all that.
I do agree, my lords. The same view was expressed by my lords on the last date of hearing. Lords, then,
We are pushing it too much.
no, my lords. Then what happened, my lords? I pointed out, though they say, my lords, it is, my lords, a project loan. Then I made this.
What the thing is, now the bank, even if you pay the entire amount, that property cannot be, if it is sold, it's a different aspect.
Lords, if
Otherwise, they can't give the property to you because you
my
are
lords,
not the mortgager.
if it is sold, my lords, so then we will be out of the building. That is why we are saying, my lords.
Without selling the property, how can they give you? You tell.
No, that is what we are, that is why I made the submission, my lords. Let this matter be referred to mediation also, my lords, so that we will negotiate with them.
How will the bank settle with you when you are not the owner of the property? You
Lords,
are not the mortgager of
My
the
lords, the
property.
bank is also in some of the suits, my lords, bank is also party.
Then settle it before the.
That is what
civil court.
that is why what submission was made by me, my lords, on the last date of hearing. Now, my lords,
Please understand, I have even find fault with the bank in cases where the bank.
here also, my lords.
No. If they give something to you, then we have to find fault with the bank because you have nothing to do with the property. As per their this thing, the property belongs to your vendor and he is the mortgager. Even if you pay the entire dues also, they can't release the property in your favor.
They don't, we are not asking for that.
Now, the only way you can get into possession of the property is by putting the property to auction and purchasing the property.
That is what we are requesting them. Precisely, that is what we are requesting. And on the
What is
last,
that you are requesting, that to put the property to sale?
my lords, we have requested, my lords, sir, instead of now, since a series of litigations are there, instead of bringing this property for sale or by way of auction, lords, with the private treaty, you said sell it to the individual apartment owners. That's what we are requesting. And on the,
For that, what they should, if they have to go to a private treaty, what is the procedure?
my lords, sir,
First of all, they have to put the property to auction. When it is not working out, then they'll go for the private treaty.
please, that is why, see, my lords,
Further, they have further to.
earlier, my lords,
We have
earlier,
to vacate the stay.
my lords, earlier property was brought for auction. They could not, my lords, go ahead with the auction. We have paid the amount. There is no dispute regarding that.
If that is what is available, but you can't seek a remedy under under 226.
Now,
of
my
this
lords,
nature.
now the bank also, my lords, colluded with the respondent number 2 for this reason, my lords. Now, they say it is a project loan. When it comes to, my lords, other individual apartments,
Absolutely, you have no connection with the bank. neither you are a borrower.
I have
nor
no
a
connection,
mortgager.
no
Now,
connection with the bank.
You can't even, I can understand, you are a home buyer, then you say that there is collusion between the buyer, the bank and the developer. But no, you have nothing to do. You have blindly believed on somebody and given the money, and you will pay you will have the consequences of it. You have to face it.
Now, my lords,
And there cannot be any direction from this court to the bank to say, you sell the property, you give the possession.
no, we are not requesting for selling the property to us, my
What
lords.
else? What is the prayer? Let me see.
My lords, kindly see. Auction sale notice was under challenge.
Yes, what is wrong with the auction sale? The bank has every right to put the property to sale. No, these are not the cases where we can examine what is the conduct of the bank. For the reason, you have nothing to do with the bank, isn't it? If it is, you have any semblance of this thing with the bank, we can examine their conduct.
That is what, my lords, on the last date of hearing.
That's what I'm repeatedly saying.
No, my
In
lords,
fact-
then, my
but-
lords,
But I have also asked them to file all this, but it boils down to the point, what is that the court can do?
lords,
court
ultimately
cannot do
to
anything.
protect, my lords, now we are before the court of laws. Petitioners and my lords, other similarly placed
Civil
persons.
court is the only place where you will get the
My
relief.
lords, now the problem what we are facing is, my lords, if proceedings are initiated under the provisions of Securitization Act, then civil court cannot entertain, my lords.
The problem is, at the same time, though you have the problems, unless and until the court has the power to do it, it cannot do it. That is the difficulty of the petitions, which can't be addressed by the court. However, how many years this matter petition is pending, ultimately you were not entitled for any relief from this court.
Lords, that is why, my lords, we have been consistently requesting them to say,
They
my lords.
also can't do anything to you.
Lords, ultimately, my lords.
Be your builder. Ultimately, you can take action against your vendor.
But if the
Your
property is
vendor-
brought for auction, my lords, the practical difficulty is what we are facing, my lords. If the property is brought for auction, lords, then we are, my lords, saved by the virtue of some interim protection given by the courts. Lords, admittedly, division bench of this honorable court also, my lords, granted in interim order in commercial appeal. I have produced that order copy also. To protect protection insofar as protecting the
Take that to
possession
a
is
logical
concerned.
and not
Now,
this
my lords,
Will not, because it is unfair on the part of the court to give any order to you and stall these proceedings. That's a public money, whatever your builder has
lords,
taken it.
we are ready to, we are offering money, my lords, bank, ultimately bank is,
Not take it.
lords,
That is
ultimately
what-
bank is concerned with
fact-
their money.
In fact, I have find fault with the bank where they have accepted these kind of transaction. And in fact, I have asked Reserve Bank of India to look into the affairs of the bank.
see, my
Who
lords-
is who is taking the
Here,
money?
here also, my lords, the
Who
dual,
is taking the money
Yes,
from a person who
Yes.
is not their borrower?
my lords, here also, my lords wanted to know. Lords, on one hand, they are contending that it is a project loan. On the other hand, they say, my lords, we have sanctioned loan to 9 other apartments.
Those kind of things
Project,
can be
that is all right,
decided in a case where the petitioner has a locus to question. Then comes the conduct of them. No, you have to, you have to cross that threshold.
My lords, I have the locus, my lords, there is no doubt
How-
with regard to that,
how-
my lords, now by virtue of.
No, no, a public law remedy.
My lords,
How do you have a right to file a writ petition?
my lords,
I can understand you have a right. You go before, you have went before the civil court.
KRT, my lords,
And KRT and everything. But on 226, what is your right?
I seek, my lords, till tomorrow, my lords, I'll
Yes,
advise
yeah.
my parties accordingly.
Tell them, it won't, better to agitate your right before the court, which can deal with it tomorrow,
Interim order to continue.
tomorrow.
Till number 7. Somshekaraya RP.
Yes.
Bank has issued notice.
According to you, what, I am
Well,
not
actually-
able to understand your case even yesterday. That's why I posted it to
Please,
today. What is
please.
it?
My lord, the property which is other than mortgaged, they have included 54.54 square meter extra in the schedule, my lord.
What do you say on that?
Your lordship, B schedule property, whatever is there in this sale deed, our borrower has purchased. Same thing we have mentioned in the notice also.
Now, what is the
he-
relationship between you and the respondent?
He is the
I am the
seller.
owner of the property. I have sold flat number 1.
No, you're the owner of the property.
Yes,
You
madam.
sold the property to second respondent.
Yes, madam.
Second
Your Lordship, can
respondent
you
has
turn to
mortgaged
page
the
number
property.
27, madam?
Second respondent mortgaged the property
madam.
and now they have initiated surface
I
everything.
have no objection. What is mentioned in the mortgage deed,
Where is
madam?
the sale deed executed by you?
Your Lordship, can you turn to the sale deed, madam? Page number, description is at ink page number 31, madam.
31.
31, madam. And now your Lordship, can you turn to the description mentioned in the,
You have sold both Schedule A and B property.
Yes,
There
ma'am.
is no difficulty
Yes,
on that.
It
Yes.
is enough.
Please come to the auction notification. That's
that
it.
action notice, the position notice, madam. Section
it?
14, they have challenged.
Where is it?
Madam, your Lordship, kindly turn to page number 50, annexure G, madam. Annexure G.
Where do you get the property?
297 square meters, so and so. Measuring 351/91. We have no objection for 297/28.
Where is it? Please, here it says, property being on the first floor,
Yes, madam.
having a super built-up area measuring 297.28.
Yes,
You have no
ma'am.
objection to that?
Yes, madam.
Square meters constructed on the property bearing municipal number.
Yes, madam.
Situated at so-and-so, Bangalore, measuring east to west.
Yes, madam.
19, you have problem with this measurements?
Yes, madam. Your Lordship, can you turn to page number, sale deed, page number 32, madam.
32.
32, description, B schedule. This is the actual measurement property sold to B schedule property. Out of 297 point so built up area together with 1,000 square feet. Now they included this one, madam. The
Built-up area
351.91.
on the first floor you have
Yes, ma'am.
sold.
Yes,
Constructed in the Schedule A property together with 1,000 square feet of undivided share, right titling. Now,
in
what
fact,
did they
madam,
do?
this has been also clarified in the sale deed itself, madam.
Along
Page
with
number
together
27.
square feet of undivided share, right and title interest of the property, along with one parking space in the ground floor.
Yes.
I'm not able to understand what is that.
Madam, you are actually, that is clarified in the sale deed itself, page number 27.
What is it? They have also said the same thing. What is there in the B schedule?
Madam, I'm, this 351.91, madam, this is I'm worrying.
Your Lordship, may I submit something?
Totally measuring
telling
351.91
total
square
350
meters together with 1,000 square feet.
Total
This is, madam.
351.
Well, actually, this will clarify in the page number 27, madam. Page number 27 of the sale deed, madam. Para 3, para 2, madam. And whereas the vendor is in funds of legal necessity, he has agreed to sell 297.27 of super built area, major portion towards east on the eastern side, a tiny portion of measuring 54.54 square meters of super built area retained by the vendor. Now they have included this 54.54.
We have not
And
mentioned
clean.
anything about 54 minutes.
Hmm?
We have not mentioned anything about 54
Well,
meters.
let
in
them
the-
mentioned in the possession notice, madam, B schedule property. I have no objection.
What did they
Bank is
Whatever it is
interested.
there, madam, let them mention.
What did they mention, you tell?
Malad, now they are Malad. 297, now this, contrary to the B schedule property, they have mentioned 297 square meters property bearing municipal number so and so, and not 2,000. Totally measuring 351.91 as against 297/28.
That is the area total schedule constructed on so and so, which measures so as
No.
constructed on.
Look at page number 32. It speaks about 297.28 square meters. In your, it says measuring 351.91 square meters.
That is the entire area. We are also telling.
No, not entire area. You are only bound by the document. Document says 297.28. How it becomes 351.91?
May I read for a minute?
Uh,
I'm reading from page 50.
50?
Page 50.
Uh.
The undersigned, being the authorized officer of the bank, inform you that one of our borrowers, namely Sri Santosh CN, had availed credit facilities from the bank. Accordingly, being the owner of the property, have created mortgage in respect of the property being on the first floor, having a super built up area of 297.28 square meters. That is what mentioned in the B schedule in the sale deed also. And next,
Along with 930 square meters.
constructed on the property bearing municipal numbers
No,
also.
1 minute. We will look at Schedule A property. What it says, total measuring 351.91 square meters along with 930 square meters of residential building standing thereon. When it comes to your advertisement, square meters together with 1000 square feet of undivided share. What is this?
In all apartments, every single unit of dwelling unit will have a share in the land. That is an undivided share.
Whatever is mentioned in A and B, you sell the property as no objection. Your description should match the document, the whatever is mentioned in the sale deed.
Exactly, schedule B, same thing we have mentioned, Your Lordship. Is constructed on the property which measures so and so. That's all. We are interested in
Clarify that.
Bank is
I
in-
will clarify, saying that as per the document dated so and so, the respondents can only go ahead with the auction as per the document, not anything above or below.
We are also, bank is also not.
That I'll clarify. What
not
you are
interested-
saying, I'm also saying the same.
Not interested in anything other than B
That
schedule.
I'll clarify. Please come. The petitioner sold the property in favor of the second respondent by way of a registered document, registered sale deed.
14/10/2006.
14th October 2015. As per the said document, Schedule A property, that is at page 31, as it is you type it, the entire one. Then page 32, Schedule B property. And this was mortgaged to the first respondent bank. The first respondent, as the petitioner has failed to pay the as the petitioner was irregular, as the second respondent was irregular in paying the amounts, the first respondent bank has initiated the proceedings under the SARFAESI Act, and they have issued a notice under section 13(4) of the SARFAESI Act. The petitioner, who is the vendor of the second respondent, is before this court stating that now the bank is auctioning the property which is not mortgaged to the first respondent bank, and the measurements in the they are auctioning the property more than what is mortgaged to them. It is submitted that the petitioner has no objection if they conduct the auction as per the sale date, but under the guise of the same, they cannot put the petitioner's property to sale. Next paragraph. When counsel appearing for the first respondent bank submits that they are going ahead with the auction as per the mortgage deed and as per the document, that is the sale deed, which is executed by the petitioner in favor of the second respondent. Next paragraph. This court has, having heard the counsels on either side, peruse the document, as it is a consistent case of both the petitioner, case of the parties, and also it is a submission of the learned counsel for the first respondent bank that they're only auctioning the property which is mortgaged to them as per the sale deed dated 14th October 2015. This court has
Schedule B in the mentioned. Schedule B may be mentioned.
A and B both.
No, Schedule B.
No, we were permitted to sell Schedule B property.
In that view of the matter, this court is passing the following order. The respondent, the petition disposed of, directing the respondent bank to go ahead with the auction only in respect of B schedule property as mentioned in the sale deed dated 14th October 2015. Accordingly, the petition.
Your Lordship, maybe now no notice was issued, maybe permit to file wakalat.
So and so. is permitted to file wakalat on behalf of the respondent bank. Yes, next.
Oblige,
Number
Lordship.
8, Nagaraj Shetty for petitioner 8.
This also tomorrow?
No,
Bajaj Finance.
it's a very short issue, my lords. as
Bajaj Finance.
Bajaj Finance. But what happened was your lordships relegated me to the DRT. I have come back from the DRT. So now
It's an
essentially.
order from the DRT.
From the DRT. So I'm,
Yes.
yes. Lords, can I pursue your lords? May I kindly have a look at page number 550.
What is the order passed for the DRT?
Lords, the DRT says it's barred by limitation, paragraph number 19. Lords, your lordships disposed of the writ petition on 10/11/2025.
10?
10/11/2025.
Hmm.
The application before DRT is filed on 25/11/2025.
25?
11/25. And the sale
What
takes
was-
place.
What was questioned?
Lord, sale notice was questioned in the writ petition. In the writ petition.
Dated.
Lord's sale notice is dated 12/7/2023. I'm sorry. Yes, 12/7/2023.
12/7/2023.
Yes.
When did you come before this court?
Lord's 23.
No, immediately. What
Lord's,
was the
yes.
time?
Lord's the writ petition was filed on 26/7/2023.
26/7/2023. That is within 14 days.
Yes.
Hmm. Hmm.
Lord's,
Then,
if this
the
period
court
is
has granted
excluded.
That section 14 benefit
If
is
section
also-
14 benefit is extended, my lords, I would have been well within limitation.
Where is that order?
Lords, page 50, your lords, my kindly see, my lords, only to indicate the date of filing of the petition and your lordship's order, my lords. They have not produced your lordship's orders. Can I just pass it on, my lords? This was the order passed by your lordships. Lords, something which is very peculiar is, lords, at page 51, if your lordships were to see the order sheet, because the sale takes place in respect of a property which is worth about 5.5 crores at 1.9 crores, after your lordships passed an order saying that you have to deposit 50 lakhs, subject to which interim order is granted. I deposited 50 lakhs. After depositing 50 lakhs, I came before this honorable court and made a statement that my due is only 3 lakhs as of today to the bank. I don't owe anything further to the bank. Lordships passed an order. Learned counsel for the petitioner submits that substantial amount having been repaid, the outstanding amount is only 3 lakhs as of today. Lords, we have the statement of objections which shows, statement of account which shows that as on that date, only 3 lakhs was outstanding. The same is disputed by the learned counsel for the respondent number 1. Respondent number 1 is directed to supply the statement of outstanding amount within a period of 1 week, which never happened. At page number 51, my lords.
No, I'm looking at this order.
Lordship's order, please. Not that the fact that we have not complied with the order was not factually, my lords, correct, because we had actually deposited. It is deposited before this honorable court, 50 lakhs. Even now it is in deposit before this honorable court, which is recorded by your lordships, my lords, in the order dated 27/10/2025. We have also produced that statement, my lords, before your lordships, that as a matter of fact we have deposited.
Within a period of 3 weeks from the date of receipt of the copy of the order.
Yes, we have deposited 50 lakhs is deposited, my lords. We have produced,
This
no, that
order
was
is-
recorded. That's the
Order
reason.
is passed on 10th November 2025.
Yes,
And by 25th you are before the court.
yes,
Before
my
the
lords.
DRT. Then now let's see the order.
Now, lordships may kindly see paragraph number 19 at page 78.
Paragraph 19 at page.
Page 78.
Yes.
It's a property of measuring 16 to 14.
Then why did you file a petition to condone the delay?
They should have filed it under section 14, my lords.
Hmm.
They filed it under section 5. That's the only mistake.
The court said it does no, it
But
cannot
these
convert.
facts were what was reflected before the court. That the sale takes place after the writ petition is filed.
The court is right in saying that this essay is admittedly filed with the petition to condone the delay in filing the same.
That principle of law I will never dispute, my lords. Your lordships have taken that view. But question is, when we had placed it before the court had the benefit of all the materials. That the writ petition was filed, my lords, challenging the sale notice before the sale took place. After the writ petition is filed, the sale takes place. Then your lordships passed an order, my lords, on 10/11/2025. 25/11/25 was already before the DRT. Not substantial justice has to be done, my lords, on technicalities. And the difficulty is for 3 lakhs, which was outstanding as on the date when your lordships had passed the order. 3 lakhs was outstanding, my lords. My property of 5.5 crores is sold at 1.9 crores.
Who are the respondents in this? Auction is conducted, then the party must be there.
Yes, my lords.
Private
That is GR Prakash, second respondent.
What is the stage now?
Pardon, my lords.
What is the stage now?
The
Stage of the proceedings.
lords, DRT has
The
closed it.
SARFAESI proceedings.
The DRT has now closed my case, my lords. Possession with us. Possession is with us. They have not taken possession from us.
Who appears for this Bajaj Finance?
That I'll have to find out, my lords. I'll try to find out.
Who appears?
Bajaj Finance.
Bajaj Jeevan Kumar. I'm told Jeevan Kumar, my lords.
Jeevan Kumar. We'll have it tomorrow. I'll pass the order tomorrow.
Please.
The land counsel, the petitioner, says the copy of the writ petition on Mr. Jeevan Kumar. Mr. Jeevan Kumar is directed to take notice and the petition saw the copy of the writ petition. And he shall get specific instructions. Let's just matter tomorrow.
Please, great.
Abdul Rao, petitioner, Riyavi.
My lords, I'm challenging the transfer of proceedings from the and everything matters were listed yesterday, my lords.
Exponent, my lords.
What is the number?
Yeah, WP 13044 of 2026.
WP 130.
And WP 13115 of 26.
Write it on a paper.
Please,
List
ma'am.
along with so and so, same order as there in the other petition.
I'm most.
My lords,
Yes.
my lords, I'm for the respondent. I'm not sure what order is passed in the other petition, my lords. I'll just make
No,
two.
in the other
No interim relief
in
was
the other
granted.
petition, I said, they have approached the DRAT or the DRT in Chennai, 23 and 24. So there will not be any interim order now.
Okay, fine.
And the
Yes,
court
ma'am.
will not the main matter itself.
Yes,
Once the
ma'am.
objections are filed.
My lords, no, I'm mostly.
Copies may be served on me, my lords.
Copy serve on them.
I'll-
Then counsel the petition, serve the copy of the writ petition on the counsel to the respondent. Yes.
Still number 10.
Obligation, lords.
Still number 10.
Yes, 10.
Ismail Ahmed.
My lords, I made my submissions yesterday also. Your lordships will remember two things, my lords. One,
No, tripartite agreement is there, then we are entertaining those writ petitions and the batch are pending.
yes, my
Because
lords.
the only, you appear for the respondent.
Respondent 1 and 2, Union of India.
Union of
Finish.
India. What is the stage now?
My lords, there are two issues in this. That's why I was trying to make my submissions. One, yes, this is a subvention scheme. The second issue, my lords, is that 13-2 notice is issued. After that, I filed my objections. Within 15 days, my objections have not been considered by IIFL, which is R6 over here. I have continued to send my representations. None of that is considered. They've converted my loan account into an NPA.
When was the construction? When was the tripartite agreement? When
My
was
lords,
the loan?
This is 2016 loan.
2016
loan.
Construction is complete?
Construction is stalled, my lords. It's an empty, this land. There is no construction at all. Only one tower is
From
constructed.
when they have initiated the proceedings on the 13th?
That is in 2025. They have initiated the proceedings. 2 months.
The counsel for the petitioner submits a petition is a home buyer. There is a tripartite agreement between the petitioner, the financial institution and the builder. The builder has not even started the construction.
One tower is constructed only.
One tower is constructed. And the respondents have initiated the proceedings against petitioner. It is submitted that in a batch of petitions, this court has granted granted an interim order not to take any coercive steps against the respondent financial institutions, and a batch of writ petitions are pending before this court. In the light of the submissions made by the petitioner, there shall be a direction to the bank not to take any coercive steps. List along with that batch number. That batch is there. No? That's Saturday came. Which is coming up on 9th of.
9/6.
That batch. Yes, list along with so and so.
Great for me.
Yes, 11.
Case number 11.
Here for petitioner in this case, Lord. Lord, in this case, Lord, the one Meena has availed the loan on 17/3/1998, Lord. A loan amount is that 2 lakhs. Annexure C, page 31. Loan amount is page, Annexure C, page 31. Lord, kindly see the page 34 is the details. The principal amount availed by this one Meena is the 2 lakh rupees. As on the 4/12/2024, the amount due was 11,57,000. So this petitioner before this honorable court is neither the borrower nor the guarantor to that loan. This Meena has been executed the gift deed in favor of her daughter. Thereafter, she has sold this property in favor of me. So the loan, principal loan was sanctioned on 17/3/1998. The demand notice was issued on 4/12/2024 after lapse of 26 years.
When did you purchase the property?
On 17/2/2021, Annexure A, page 19.
What is your contention that the SARFAESI proceedings cannot be initiated?
Yes, Lord. The reason is, Lord, that in view of that Ministry of
The
Finance.
fact remains is,
Pardon,
forget about SARFAESI proceedings. The fact remains is there is a charge.
Charge.
The bank has got charge over the property. And when the property is mortgaged to them, you have purchased the property.
That what happened, Lord? The principal borrower has been not there. She bequeathed the property. They executed the gift deed in favor of her daughter. So daughter has sold this property, but believing that because
Nobody has any right with the
that it is a simple mortgage, believing that the words they are purchased this property, and also that after a lapse of 24 years, 26 years, the demand notice has been issued. That has been challenged before this honorable court. In the initially had taken the defense that the provisions of SARFAESI Act cannot be invoked.
court for an amount of rupees 8 lakhs outstanding.
2 lakhs rupees more.
Premature notice, my lord. It is under section 13th of the SARFAESI Act. It is a demand notice.
First of all, on the face of it, as per the guidelines issued by the RBI,
yes,
whether the SARFAESI proceedings can be initiated
There is
with respect of 2 lakhs loan. That no, they have
That
issued
is
a
for that
circular.
reason only approach this honorable
Tax
court
of
after considering that only the court has granted the interim order.
25 lakhs or something is.
This is here, Lord, that notification that Ministry of Finance has been issued the notification. Sorry, sir.
What
The
do you
amount should
say?
be more than 15 lakhs.
May passed over.
Is there? The bank council. What do you say about that circular? Please show me.
As per the act, it is 1 lakh and above.
Huh?
As per the act.
No, the guy, the register, the
Circular, that notification issued by
has
the.
issued the circulars.
Is it for OA or for SA? SARFAESI?
No, SARFAESI proceedings are initiated.
The principal amount is 2 lakhs.
Act has to be amended, no matter. Act has to be amended, no matter. Act says it is 1 lakh.
You can't, but then why the RBI is issuing a circular contrary to that? Whatever it is.
100 crores and above with
No, whatever it is, you have to follow what RBI says. So,
certain guidelines are directive,
Yes,
my
not
lord.
like
No, no.
Certain are mandatory.
in exercise of the powers conferred by subclause 1, subclause 4 of clause M of subsection 1 of section 2 of the Securitization Act. The central
is
government
notification on
hereby makes
12th
the
February
following
20.
amendment. In the notification of the Government of India, Ministry of Finance, Department of so-and-so, dated so-and-so. In the said notification for the words rupees 50 lakhs and
And
above,
above.
the words rupees 20 lakh and above shall be substituted.
With regard to the NBFCs, which is coming in this one.
Let's read this.
It is NBFCs, my lord.
Huh?
It is for NBFCs. Those NBFCs turnover is that much, and for them there has been brought to the net. They can.
For this, what is earlier notification? This is 24th What is the
Before that
earlier-
is that 50 lakhs.
Huh?
Before that, that is the 50 lakhs.
What is that? We have to know what is that? What
Lord,
the
that is
earlier
for
settlement?
the NBFCs to come on record. It's not for the,
NBFC.
I mean, non-banking financial companies, my lord. Other than nationalized bank, private banks and this one, NBFCs.
They
Like they
can't
have-
initiate the proceedings if it is above 25.
Yes, my lord. Yes.
Below 25.
Yes,
and
my lord.
earlier it was below 50.
Yes, my lord. It is not for the nationalized banks.
It is not a nationalized bank, Lord, because
What
they-
is this? Which bank?
They-
Vaishya Cooperative Bank. It is not a
Bank.
nationalized bank.
It is not.
Not a nationalist.
But it is a bank.
Bank.
It will not come under NBFC. It is a bank.
But
That
the
is
circular is very
non-banking
clear that.
Companies, my lord. That is.
Oh, that like
NBFCs.
SAP construction company.
Yes,
After vacation, come up with your argument. This is matter after vacation. Yes, next.
Cell number 12 adjourned. Cell number 13, hearing B group. Abhishek Marla for petitioner.
Kindly pass over, my lord, senior counsel has been case. My lord, 13 has to connect with WP 4297
List along
2016.
so-and-so after vacation.
42971 of
Write on a
2016.
paper and give. List along with. Yes, next 14.
Cell number 14. Cell number 14.
The petitioner is madam. My lord, just short pass over, my lord. Senior is held up in the right in the next court. Short pass over.
Who appears for the respondent? Yes, this is matter after vacation.
Cell number 15.
At the request of counsel, the petitioner 15.
Cell number 15.
This is also after vacation.
Cell number 16.
Appearing for respondent number 2 in this, please.
What happened to 16?
Petition is not maintainable against
Objections
respondent
are
number
filed.
2. My lord, should carry-
No representation
recollect.
on behalf of the petitioner. This is matter for disposal. 16.
16.
Cell number 16.
15 after vacation.
After vacation.
Interim order is interim order may be
15 interim order extended. There's 16.
Cell number 16. Gautam Mayor.
This is no representation. This is matter for disposal tomorrow.
My lordship, my petition may be allowed. I don't have any objection for this allowing this petition because they are seeking the prayer in this petition, Your Honor.
This
Directly
is where the police said to have seized the vehicle and handed over to.
Yes.
No, let him be there. We'll pass in his favor. For business tomorrow. The 17.
Cell number 17. Cell number 17. Dhananjay Kumar.
We don't have it.
Yes.
It's under infections.
Is there it?
Hand summons, Your Worship.
What is that?
Hand summons. Hand summons was
We have filed
taken,
our-
returning the hand summons, Your Worship. They have not received, the bank has not taken the hand summons, Your Worship. They have refused to take.
You,
the
they're
hand
representing.
summons. They have refused to take it, Your Worship.
Why the bank is refusing?
Sir, it's under infection.
Not this way against which recalling application.
Why the bank is refusing to take hands on?
Your Worship,
They already filed wakalat.
may I make a submission, Your Worship?
What is the writ petition about? Let's see.
We are challenged the
Certiorari to acquire the impugned order rejecting recall application dated 6/1/2026 in OA of 20. Please come to the order. Where is the order?
page number 10, Your Worship.
Counsel for the applicant present, no representation for the petitioner. What is this IA number 1868?
Your Lordship, the IA number 1, 2, and 3 are the application that was filed by me to recall the order, reopen, and also for extension of filing the written statement, Your Lordship.
No, you file an IA to recall an order. On that day also you will not be present. Why?
Your Lordship, it was due to the oversight. There was no entry in the.
How many, what is the end to this? Once IA was dismissed, I mean, again, you file an IA, that IA also dismissed, against that you come. Now I'll again set this order, set aside this order, send it back, again you will not represent.
Your Lordship, this was due to oversight. We were not able to attend.
What
on that.
oversight? Case has been, petition stand, case has been passed over and called again. Despite that, no representation for the petitioner in the IAs. for applicant's evidence post on 18/3.
Your Lordship, it was due to oversight. There was no diary entry in the, it was due to the oversight of the council, Your Lordship. The party may not be suffered because of our mistake, Your Lordship.
What do you say?
Lord, this OA has been disposed of. What happens is she gets a stay on a particular day. And same day the OA is disposed of, they don't bring it to the notice of the court.
Your Lordship,
OA is allowed. Now the
Your Lordship,
petition itself has become infectious.
permitted to file the memo, Your Lordship, wherein the OA has been disposed of on the said date, Your Lordship. However, Your Lordship,
So
on.
what you have to do is you have to question that order. This order has merged into the final order.
Yes, Your Lordship, may I make one submission here to bring to the notice? On 17/4, Your Lordship has stayed the further proceedings in OA, Your Lordship. And on the same date, there was no sitting in the trial court, Your Lordship, in the DRT. And the bench had informed us the next date would be on 15/5, Your Lordship, which is coming 15th of this month, Your Lordship, the coming month. However,
We will not do that kind of an inquiry. Now, whatever the fact remains is, in that you can agitate all this. The fact remains is the main OA itself is disposed of, and this order dated 6/1/2026 is merged with that order.
Yes,
You have to question that. You question that. We can't know, then there is nothing to consider in this writ petition.
Your Lordship, we are filing the MA application to the recall the said petition, Your
Then
Lordship.
also this becomes infructuous now at this point of time. Please come. The writ petition is filed, seeking the following prayer. Land counsel the petition submits that without giving an opportunity, an order is passed on 6/1/2026, whereby the court has dismissed the the court has dismissed the application as also representation. It is submitted that due to some the oversight, they have not attended the advocate has not represented before the court. Then a counsel appearing for the respondent bank submits that the OA itself was disposed of on
17/4, Your Lordship.
17/4 only.
on 17/4/2026, and this order is deemed to have merged with the final order, and they cannot question this order at this point of time. Having heard so and so, considering the fact that the main OA itself is disposed of, and this order is merged with the final order, the remedy available to the petitioner is to question the said order. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to question the order that is passed in the OA.
Number 19.
Your Honor, Your Lordship, one request. Malini Vinay's name may be shown because I am on the panel. I am in
Which
the panel.
one?
The same case, 17, serial number 17.
Delete the name of Mr. Vinay Swami C. So and so submits that.
Malini Vinay.
She has instructions to
So
file.
I am the
wakalat.
panel counsel.
Huh?
I am on the panel.
He has instructions to file wakalat, appear in this matter.
I have already filed wakalat.
Wakalat is all, or then it's, just say, delete the name of Mr. Vinay Swami and so and so.
It's our joint
Submits that she has-
wakalat. It's our joint wakalat. so-
Yeah, she has, so and so has filed wakalat.
Number 18.
Much
The order shall reflect her name. Yes,
For the
May I please, Your Honor?
yes.
Appear for the
File
petitioner.
Wakalat for the respondent bank, my lord. May be directed to serve me the copy, my lord.
My Lord, we have served the copies on Ranjan Kelkar, my Lord.
No, no.
But
Soft copy they have
however,
sent, my lord. It is not
he has
legible.
asked for soft copies, my Lord. I have scanned it and sent it to him, but
To him. Let him
Lord.
get instructions. I'll take up tomorrow.
my Lord, there is,
Tomorrow,
please.
Correct. This is
This
the
is my-
case in which the action
whatever
such as
it
the
is,
challenge.
when a writ petition comes and a notice is ordered to
Take the
you,
file forward.
you're supposed to get your instructions. So and so submits, sir. There's instructions to file wakalat. This is matter tomorrow. And
May be directed for the copy.
delete the name of so and so in the and so delete the name Ranjan Kelkar. Delete the name of so and so has instructions. Counsel for the petition serve the copy of the writ petition. By tomorrow, the counsel to the respondent shall get instructions. Yes.
Much obliged.
Till number 19, parted matter.
My lords, I kindly request your lordships to take the matter up at 2:30, my lord. Senior counsel is on her legs. My lords, may I kindly have it at 2:30.
I don't know whether it is 2:30, 3:30, whenever it is convenient to the court, it will take.
Please,
May not
please.
be at 2:30. Yes, pass out.
Please, my lords.
Till number 20.
My lord, I beg to appear on behalf of respondent in this matter. It is the same matter, my lord, where, my lord,
File an affidavit, my lord. Manager was directed to file an affidavit. this quarter.
Yes.
We lost it a few.
please, my lord, I need some time. The reason is this, my lord, the very same petitioner, my lord,
Yes, Mrs.
produce the,
Martha.
my lord, I'll make only one.
No. I'll look at the affidavit then only. There are The writ petition, this court has directed the
One submission,
respondents to file the affidavit and counsel for the, but the respondent seeks time. This is matter immediately after litigation is
Now,
started.
there
Till
should be
such time-
auction notice.
till such
Yesterday
time
they should auction.
will not take any coercive step.
Auction notice be state.
That's what I said, not take any coercive step.
Much.
My lord, this matter requires some investigation. The reason is this.
You should have filed your affidavit by this time. Then I would have heard.
21.
Yes, my lord, I am
My lord,
appearing for the
affidavit.
petitioner. My lord, actually in serial number 21, initially the risk petition was filed before the Honorable Supreme Court of India. And by the order dated 7th of March 2020, liberty was granted to the petitioner to approach under Article 226. And since 2022, no objections have been filed by the respondent.
First, let's see what's your prayer.
My lord, our prayer is regarding the implementation of COVID-19 circulars. Actually, the date of NPA, the demand notice, they have turned our account NPA on 5th of December 2020. And during that time period, there was a stay order of the Honorable Supreme Court which was operating. So their actions from the beginning itself are void. And we are also seeking for the implementation of ECLGS schemes. If
Who
my
are the
lordship,
respondents?
respondent is the my lord RBI and one Canara Bank.
My lords, I appear for the bank, my lords.
Has the bank filed their objections?
No, my lords, the only relief against the bank is an ex gratia damages of 50 lakhs, my lords. That, in my humble submission, is not maintainable in a writ.
My lord.
What about this?
Already, my lord, Supreme Court after hearing granted us liberty, and the same similar matter has been decided by this Honorable High Court in Well and Kelly Information System Limited versus Secretary Home Affairs. And the circulars which were released by the RBI, the duty was upon the banks to implement them for the individual accounts. There were all conditions and we fulfilled those all conditions. Their turning of the account NPA during the stay period itself is a very serious issue, my lord. So they may file their objections. I will argue finally the matter. My lordship may keep it after vacations on any date, my lord.
Who appears for 1 and 2?
That is respondent number 2, Namita Ganesh, AG. Namita Ganesh for
AGP for R1. R1 is the Union of India.
Yes, sir.
Champ is for R1. And Reserve Bank of India, Nikita Ganesh. Why they don't appear before the courts? This writ petition is filed in the year 2022. The respondents have failed to file objections. As per the writ rule, within 45 days, isn't it? 45 days writ rules to file the objection. 30 or 45 days. As per the writ rules, within days they have filed objections. But unfortunately, in none of the writ petitions, the respondents are filing the objections. This is matter on 8th of June. By the time all the respondents can file their objections, or else the right to file the objections shall be forfeited.
Grateful. Grateful.
Cell number 22.
For respondents 5 to 8.
Notes, I appear for the petitioner, my lords. I pray for a week's time, my lords.
Because
After
already-
vacation, my lords. My senior is held up in some part-heard matter today, my lords, in the
Why
final.
you were not there yesterday?
Yesterday I was there, my lord.
Why the matter is under dismissal if you are there?
It's in the last occasion, my lords, even I was held up in some other court. My
No, your
junior-
senior is held up in some other court.
Notes, we have
When is it possible for both of you to be free?
notes, we have only 3 juniors associates, my lords, right now. 2 left the office.
Then engage 2 more.
No. That's our problem, lords. Sorry for the
Yes.
inconvenience. Kindly have it some other day, my lords. after
Any
vacation.
agency in this matter?
My lord, what had happened was they are subsequent purchasers after the property is acquired. There is allegation of fraud, everything on their part.
Any stays there in this?
An interim order was granted 3 days ago. When it was posted for dismissal, this honorable court did not extend the interim order.
So there is no interim order now.
There's no interim order.
Last occasion, my lord,
Does this matter after vacation? At the
Uh,
request of learned counsel, the petitioner delete from the caption, dismissal 23.
Is it possible to fix a date, my lord?
Huh?
Is it possible to fix a date?
Listed on 17th of June. Yes, 23.
Case number 23 adjourned. 24. Vikas M.
Yes, I appear for the petitioner, my lord. In this matter, my lord, covered by judgment of this honorable court, my lord, sir. Covered by judgment of this honorable court, my lord, Annexure G series, my lord. That the
Annexure?
prayer of the writ petition is that, my lord, to quash the endorsement issued by the respondent number 2, my lord, sir, dated 12/4/2021, refusing to, my lord, to execute the rectification deed.
Quashing the order dated 12/4/2021 passed by respondent number 2. Who is 2?
That the aircraft employees
First
association.
I appear for respondent number 2, my lords.
The aircraft employees house building cooperative society limited.
What is that? Refusing to execute rectification deed.
Yes, my lord.
And what is the covered order?
My lords, Annexure G, my lords, may kindly be seen, my lords.
Heard Sri so and so. All the land councils of the issue and stands covered by orders.
No, my lords. My lords, it is not covered, my lords.
My lord,
That is regarding,
What are you supposed to do? How can you file this order? You're supposed to file the order in WP numbers 2006.
that is produced, my lord. My lord,
Where is
kindly
it?
see, my lords, Annexure F, page number 37.
30?
37. 37. The operative portion is, my lord, 38. The interim order, my lord, passed in the WP number
1
7.
minute, let me see. 30?
38, my lord, the operative portion.
This
38, my lord. Annexure F.
order by whom?
My lord, in WP number 50216 to 50218 of 2012.
Abstain from convening the property in favor of third parties.
My lords.
It is an interim order.
Yes, my lord. But in the
After
subsequent
that-
writ petitions, my lord, in the subsequent writ petitions, the interim order, my lord, was granted only to restrain from conveying the property, my lord.
We are on final hearing. You have to argue finally.
Yes, my lords. My lords, my contention is that, my contention is that, my lord, as per Annexure G, my lords, my kindly be seen, the coordination of this honorable court has passed an order. My lords, page number 41, my kindly be seen. In the similar circumstances, my lord, this honorable court, my lords, allowed the writ petition and directing the respondent number 2, my lord, to execute the rectification deed. My lord, para number 3, my lords. Para 3, page 41, my lords. The interim order passed in WP number so and so dated 8/2/2013 does not bar the second respondent society from executing the deed of rectification.
What is the relief? It just said, set aside, consider in accordance with law. If you want the same order, I'll pass.
my lords, if I may make a submission.
My lords, in fact, my lords, the
No. If you want this order, court has no difficulty. We'll set aside this order and ask them to act in accordance with law.
yes, my lord.
My lords,
My difficulty is that, my lords, the possession certificate is also issued, no objection certificate is also issued.
My lords, these writ petitions are pertaining to extent, my lords. The dispute with regard to extent. Now what they're seeking for is an additional portion of land which is adjacent to their property, my lords. It is not covered by.
Can't do.
It is which we can't do. my
That's what
lords.
I'm saying.
That's in fact,
Order, what he is saying is to set, order is set aside and you are directed to consider in accordance with law. In accordance with law, it is not permissible. You will reject it. But you want this order, will grant.
My lords, and one more thing.
that's my submission is that, my
Lords,
lord,
my
my
lords,
lord, for
may-
the additional land, my lord, he had paid the amount. My lord, Annexure E, my lord, is the receipt.
Have they taken the money?
Yes, my lord. They have given invoice certificate,
File your
my lord.
objections.
My lord, may I produce,
Objections
my
will
lord,
be to file.
The respondent should file their objections. when
Yeah,
it's
my lord,
stated.
they have
Lords,
filed the application for.
This is matter on 18th of June. The
May I
delete from the
produce, my lord,
caption
the-
dismissal. Yes, next.
Case number 25. Surendra and
Petitioner in this matter. Yesterday I made as per the sale.
What are your instructions?
Yesterday, demands were delivered to the authorized officer. He was here yesterday. Essential measure. I acknowledge the receipt of the demand draft towards the balance of sale consideration.
So we'll allow the writ petition.
Petition.
Because ultimately, bank wants money. You got your money.
We have, that's the no issue.
So we will allow the writ petition. Yes. the.
Elected to accept without recording my consent.
Yes, yes. I will not say that you asked the court to, you have
When
consented.
bank
for-
wants that, what happened is, because it was after rejection of the mail forfeiting the deposit, the matter goes up to the committee. That will take a lot of time. So in fact, AGM wanted the money to be taken to
Yes,
complete the
yes.
matter.
The writ
And then
petition
the
is
direction of
fine.
the Honorable.
Sing the following prayer. The petitioner is an auction purchaser. He participated in the public auction sale and declared the public auction conducted by the respondent bank and declared as a successful bidder. The respondent bank has issued a letter of intimation of sale stating that the petitioner is a successful bidder. Petitioner has initially paid 25% of the bid amount as per the sale notice terms and conditions. The bank has issued the sale confirmation letter dated 2/3/2026 to the petitioner. It is stated that the petitioner has gone to his native place for some personal work and to arrange the balance bid amount. At that time, the petitioner was suffering from illness and the doctor suggested that he had to take rest and he was put on medication. The respondent bank, after receiving the letter from the petitioner, has issued a termination and he has requested the bank to extend the time. The respondent bank, after receiving the letter from the petitioner, has issued a termination letter without considering the petitioner's health condition by letter dated 23/2026. It is submitted by the land counsel for the petitioner that the petitioner has requested the bank through mail to extend the time to pay the balance amount by explaining his conditions on 16/3/2025. In spite of the same, the bank has not withdrawn the letter dated 23/2026, whereby the amount that is paid by the petitioner is forfeited. Land counsel appearing for the petitioner submits that the petitioner, as per the, it is submitted that the auction was conducted on
27/2/2026.
27?
To 2026. Your Honor.
27/2/2026. Amount has to be paid by
16/3. Entire
amount-
sale consideration by
Huh?
16, entire sale consideration by 16/3.
entire amount has to be paid by 16/3/2026. As per rule, what is that rule?
9
Extension
sub
of
class
time.
4.
As per the
Rule?
9 sub class 3 and 9 sub class 4.
9/3.
9 sub class 3 is the depositing the amount by the
Rule
action
8.
person.
Extension,
Extension 9 sub class 4. Your Honor.
as per,
Security interest and person.
as per rule 9/4 of the act, of the rules, as per rule 9/4 of the SARFAESI rules, the bank has the power to extend the time by another 45 days.
Up to 90 days.
90 days.
Up to 90 days. It is submitted that the petitioner has it is submitted that the petitioner has given the DDs for the remaining amount as per the directions of this court and as directed by this court. It was accepted by the land counsel for the appearing for the bank.
Yes.
Bank. It is submitted that even if as a bank has got the power to extend the time by 90 days, that 90 days will complete by 27.
27/6. Your Honor.
90 days is from the date of that 16/3 or from the date of auction?
From
Date
the
of
date of
confirmation of this.
confirmation. Your Honor.
From date of confirmation of this.
Confirmation of sale is when?
2/3.
On 2/3, my lord. 2/3, it was, he was required to pay on 16/3. From that date, it is 90.
16/3. So from 16/3, how many 90 days means? 4, 5, 6 till June.
Enough time was there.
Huh?
Enough time was there. Enough time was there for the petitioner.
No. That 90 days will elapse by the month of June.
Yes, sir.
Yes, June.
It is submitted that the bank has got the power to extend the same by 90 days and the petitioner and the bank without forfeiting the amount could have accommodated the petitioner. It is submitted that this action of the respondent in forfeiting the amount without extending the time is bad in law and the same needs to be set aside. Land counsel appearing for the respondent bank submits that the bank has a discretion as per rule 9/4 to extend the time, but however, for the reasons stated and for as satisfied by the bank. In the letter that is addressed by the petitioner the petitioner has only stated that if a reason, if the time is given, he'll pay the amount when he is going to pay the amount and all. There is no clarity in the said letter. As such, the bank has bank has not considered extension of time as per Rule 9.4. Correct?
Yes, ma'am.
As per Rule 9.4, it is submitted that there is no illegality with the order impugned. The auction was scheduled on 27/2/2026 and confirmed on 16/3/2020, and by 16/3/2026, the petitioner has to pay the entire amount. And as per Rule 9.4, the bank can extend it by another 90 days. However, for the best reasons known to the bank, without considering the case of the petitioner, has issued the impugned proceeding by forfeiting the amount. When the matter came up before the court, and ultimately the concern of the bank is to have the money, but not to again go for an auction and litigate the matter, and balancing the interest of both the bank as well as the petitioner. This court has directed the petitioner to pay the entire amount and immediately by way of two DDs.
Three
DDs. Yesterday's date. He has paid the entire amount, and this court has directed the counsel for the bank to accept the same. In the light of the same, the petitioner has paid the entire amount as per the auction conducted by the bank dated 27/2/2026. In that view of the matter, this court is passing the following order. The impugned proceedings stated. Proceedings
23. Dated
23/2026 is set aside, and the respondent banks shall proceed further and complete the formalities in accordance with law. Yes.
Great.
Final hearing, cell number 26, O Mahesh.
You that? Order sheet. This is a MFA of 2014 filed by the insurance company. On 2/7/2014, stay was granted on the condition of depositing 50% of the amount. Thereafter, the matter underwent several adjournments. On 10/2/26, the order sheet reveals that counsel for the appellant is absent. On 12/3/2026, the matter was directed to be listed on 13/3/2026. On 22/4/2026, the matter was admitted and directed to be listed on 24/4/2026. On 24/4/2026, at the request of the learned counsel for the appellant, the matter was directed to be listed on 29/4/2026 at 2:30 p.m. It is made clear that no further adjournments will be granted on that day. Oh, because it is set at 2:30. That's why it's not appearing. This afternoon we'll call this matters in the afternoon. Then what about next 27 is also same.
27.
All these MFAs are, I think, all at 2:30. We'll call it 2:30. Is any password?
28, madam.
Password that is
28, serial number 28.
20?
28.
MFA.
Yes, my lord.
O Mahesh.
Actually, on the day when the order was passed, I said it will take it up at 2:30. I think he's not appearing, Mr. Mahesh. If he doesn't appear at 2:30, I'll dismiss all these appeals, all the appeals of the insurance company.
Please.
Any passwords?
Please, my lord, serial number 2.
Serial number 2. Senior counts. I think this is tomorrow. I'll take up, Mr. Vignesh Shetty in the morning itself.
Please, please. In fact, my lord, they paid 50 lakh rupees. That, my lord, I received the instruction from my client. That, my lord, maybe get it recorded. This, they're undertook before this.
Yes.
They're undertook before this honorable court. We are going to pay 50 lakh rupees, which they paid.
You have any other?
The same matter, serial number.
Same matter.
After 15 appearance, within 14 days.
14 days.
After 15 appearance, that is usually 30 days notice. After 15 appearance ಆದ್ಮೇಲೆ within 14 days ಅಂತಿದೆ. Usually notice the 30 days after the notice. Notice issue ಆಯ್ತು. Usually in ಇದೆಲ್ಲ ಎಲ್ಲ ಪಾಸ್ವರ್ಡ್ ತೋರಿಸ್ತೀವಿ ಸರ್. ಆಲ್ ಪಾಸ್ವರ್ಡ್ ತೋರಿಸ್ತೀವಿ. 220 ಇರೋದಿಲ್ಲ. ಅದು VC-ಗೂ ಕನೆಕ್ಟ್ ಆಗಿದೆ. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಮೊಬೈಲ್ ನಂಬರ್?